Rajan. He's now retired part of the registrar. So he has given the Darjeeling tea, the GI of the Darjeeling tea also. So definitely GI has been, had been granted by him. But Tirupati Laddu is under the challenge again, that's the thing. But once you file the GI, but remember, the GI, the moment you think for the GI application, it is not any individual or any company's matter. It is a community. If you think about that area, the people or population of that particular area, he is thinking, they are doing something which is very unique in nature. I have seen for Hyderabad, some of the sweet, different kind of the sweets like people like and all those things. I'm sure about that, that is not protected by GI because there is no GI tag with their, I heard about that G. Pola Reddy is a famous sweet maker of this Hyderabad. But probably, even same thing happened with our West Bengal, that is called KC Dash. So they claim themselves that they are innovator of the Rasgulla, that technology and all those things, when the Britishers were ruling India. Now they got, our Bengal also got this GI of the Rasgulla. Then government of Odisha came and they challenged that GI. So they said, no, Rasgulla, we have also kind of the evidence. They showed that at the Lord Jagannath temple, that Rasgulla was presented as given as the prasadam. So some of the documents they brought, I remember that's the day the hearing was going on. In that office, even I had some other hearing, but surrounded by the journalists outside with the cameras. The Chief Secretary of the Odisha came and Chief Secretary of West Bengal was there. Very interesting hearing. Flooded with the people, means like our press, media outside. But somehow the Odisha submitted some document which was very interesting also. So now this is the first GI in India which is segregated in two states. The Rasgulla GI of Bengal, they write also GI, and also the GI of Odisha. That is very interesting case. Even many foreigners they asked me, when I visited those countries, how come you give the protection in a two segregated and equity manner? That is a very debatable subject undoubtedly, but I don't like to discuss on that platform. This is the thing. So GI is very, very happening because if you are living in a community, you can find that is a very good product and you can think for the GI. But you have to take the help because you have to first form a society or the cooperative body and then you can apply for the GI. But you remember the lot of documentation is required. Recently there is a brinjal. It was developed by OUT, Odisha University of Technology. They are doing very good in agricultural research work. They have come out with that kind of a GI. It's called Katamundi brinjal or something. But somebody challenged it. They said this brinjal is having that kind of quality and all those things. But I saw this somebody filed an application for the revision. But he said no, nothing like that. And all those things. Where is that such kind of a proof? So you remember even the GI is now in question. So now we are talking, because whatever we have mentioned there on my previous slides, these are related to our country. And of course, we will be, if you think for doing the business, if you have the dream for doing the business in our country, definitely you need the help of IP in a different form, whatever you fit in. Now the question is that you have your business in India. As they said also, the DRDO authority said, because we are giving the technology to the many foreign countries. So definitely they are also looking forward to us because they know this India is also very good in the technology and research work. So therefore, you have to think that if you want to go for the global level, crossing the boundary or the geography of our country, then the feeling is totally different. Even when you make a trip also, you can understand in the same way. So that's why even if you want to take your IP outside India, then you have to have the clear strategy. Otherwise, even many big companies in India, I know their litigations, they are facing in the court of England or court of USA. I'm giving you one example of the Dr. Rangaxi. That company is gone. That is only for the IP disputes. And because they never thought of, because I will not come to that debatable topic right now, but they had to face the litigation not in Indian court, the American court. And American lawyers will charge you by per minute. They will not talk. So therefore, such big companies is just blown off only for the wrong strategy and wrong team people, inside the company. So one has to be very, very careful. If your company is really too big, you have too big risks also. Because every time you should wait for a blow. So global perspective, then if you think for your patent, then you have to go by the PCT. So this is a system. What is the PCT? That is called Patent Conventional Treaty. So PCT is nothing but you just think in that way. I am not going for too much of legal complexity and all those things. It is a kind of gateway. Like one gateway, you are filing the application. Suppose you want to file your application in 20 countries. This is a very big thing. I'm talking about that I'm well connected with the Procter & Gamble in USA. They file 700 IP matters every day. Like your aviation terminal, they have this IP terminal. The whole room with a screen and they are watching the countries and the protection. So therefore PCT you can file. It is very easy. One application you just mention there. Because a PCT is controlled by a body called WIPO. And this is based in Switzerland, in Geneva, not in India. So once you file the PCT, Indian government has no such role to control this application. It will be controlled by Switzerland. But before filing the PCT, there is, if you are an Indian authority, means like Indian company, then the government of India will ask you, first you file in a national level, then you go for the PCT. Or you have to take the legal clearance that yes, and the many inventor comes to us, means like he wants to do the business in USA, very smart person. He says, I'm not concerned with India, so why should I protect my patent in India? I want to protect it in USA, direct filing. So then you have to write to the government of India and you have to give the reason there, because why you don't like to protect that kind of IP in India. Then you can go straight away to this foreign country. Now foreign country you can go, there are choice. I asked many times, I have seen even a foreign lawyers, they are habitual practitioner with this kind of the PCT and the magic protocol and all this is good. But you better just remember, every coin has both sides. So in many seminars, I highlighted before the international practitioners, even a WIPO body also there, I have given the negative side of the PCT filing. First of all, your cost, basic application cost is very high. That you have to pay in a European currency. Later on, what is happening, like you want to file your application in 3 countries. And PCT filing will go for the 3 countries. I am giving the example of the Germany or France or Belgium. Now the situation is that the PCT body will be moving your application to those countries, you examine it. Because that particular protection will be regulating by the law of the land. So once it goes there, so then that patent office will be handling your application and you will be coming out all your objections, hearings, etc. That is the time you have to appoint another attorney who is practicing in that country. Indian attorney cannot do anything with that. That is the practice of every country. That is our IP, legal networking systems and all those things. So what happens? Because if you file a PCT application, you are paying the basic fees, then you are waiting for their objection in 2-3 countries, then you are appointing another attorney, then everything is becoming more expensive. I calculated, I showed it to the body. Just strategize in this way, like if you want to do the business in 2 countries, like your GCC countries like Gulf, you file a directly GCC countries application. Don't go for the PCT. It will be a bad selection. So you will be wasting your time, you will be wasting your cost of money, means like rather you have to pay more. It is better you file the single application in that country and get that lawyer of that country handle it right from the beginning. So he will bring out some changes. So I will come to the red point also. What happened, these are all practical problems, it's a very high altitude level. It is not for this, regular even IP attorneys, they can handle such kind of cases. So PCT filing after selection of the designated countries you have to mention and securing the patent protection in various countries. That is done. So therefore PCT filing is very, very crucial, and it is very calculative also. You have to think for your time. Your attorney should be very well versed with what is the impact of after filing the applications and where the protection will go. Now trademark application, similarly we have the system. Like many countries, especially the multinational companies, that is a trend. They come with this Madrid filing. We call the Madrid protocol. So it's fine. So even the international practitioners, they also go for the Madrid filing. In one go, they file in 45 countries. It's good. But the problem lies in many folds. You are thinking that your application is easy to get the protection. It's not that easy. Suppose in one country, like just yesterday I got a note, just kind of the mail from Israel. One of our clients is very good in your healthcare products, Renetas. I should not give the name in that way. But that Israeli company has written to me, your Renetas has been taken by another company in your country. So come and file the opposition. Just see the whole world is changing. Everybody is watching you. You are not that, okay, I am hiding in India, I am safe, and it's not that. Your trademark will be also taken by somebody else in that country. Before you start your business, you see this, your trademark is blocked. Same situation is happening in your country with 3 brands. I'm giving you the idea. 2 brands, so far my knowledge goes, 3 brands. One is your Patanjali. They are facing the problem in Bangladesh. Identical trademark has been filed by this Bangladeshi company. And now Patanjali has gone to the Supreme Court in Dhaka. Same thing with one company from Calcutta. Everybody knows it's called Wow Momo. So they are national award winner company. Rather more than that, they have crossed that boundary also. So Wow Momo's same name has been taken by Bangladeshi's company, and they are waiting to come and do the negotiation with us. And same thing is happening with the link pen. And the biggest problem is that the one American company is facing the same thing, because I'm especially globally connected with many countries, with my academic interest also. KFC facing the huge problem in Bangladesh, because KFC, it is basically the person who has copied it in Bangladesh, he is supported by good attorney. I'll not give you the name, he's a very smart guy, a very young lawyer. And I told a letter mark for at least for 10 to 15 years. So your risk is there. You are always, your business is going through gray areas, lanes and by lanes. So KFC, that particular, because how it got registered in US also, it was basically that that particular person with the beard, it's called Uncle Sam or something. So that is his distinctive feature. And that's why it got registration in USA. Same thing, it happened in when the KFC watched that, and they found in Bangladesh somebody has taken the identical trademark, almost identical. We call it not identical, we call it deceptively similar trademark. Now what happened? This KFC, they said KFC, how you have derived it? Kentucky Fried Chicken. And this gentleman said, in Bangladesh there is a state called Khulna. So he said Khulna Fried Chicken. I have the equal right. And in spite of that uncle, he has taken one priest of the mosque and with the beard. That's almost deceptive in nature. And KFC is ultimately compromising with him. And he is with that kind of idea that please let the KFC come and approach me, that please take my franchisee in your country. Not only franchisee, the sole franchisee, the principal franchisee, and he will be giving the subletting to the other franchisees. You just see how smartly he has planned his business, although it is not very encouraging. But it is the help of this IP lawyer again. So trademark is there also in various countries. Industrial design also is protected by Hague Agreement. So like design, I will not suggest you go by this international in that way. You again file the individual country. If you choose, you go to that particular country, you just take the registration. But mind it, if you want to do the business, and if your design is very unique in nature, there are many ways you will get the business connections. And once you get the orders, especially even the same with the attorneys, we get a lot of, especially our firm gets a lot of mails from different lawyers, IP lawyers around the world. But we are on guard what that lawyer wants, what he is intending to do. These are very, very important even for our legal practice, especially for the IP, because IP is not a national practice, IP is a global practice for the good standard of the IP lawyer. So therefore, you have to be careful for your business. If you get a query from that country, you hold it. Then you immediately contact an IP attorney of that country, or you talk to your IP attorney, find out whether he has already blocked your IP right in that country. What will happen? He will apply the trademark. Then when that registration process in that country will go by the hurdles, he will say this, I got is a kind of the legal permission to do the business jointly with this country, but he will take that right. And then he will come in that court, they will drag you out to that court, and you come and face the litigation. It happened with one of our clients. He's a very good in the leather bags industry, in the export market. So he was excited. He has a lot of trademark in India, and also in many countries he has a showroom in UK, very big company. But there is a order, means a particular person, he wants to start his showroom in Holland. We made him to wait for 6 months. Every day that gentleman was calling me, said, please make my process faster. I said, you will be burning your fingers very badly. Know that even he is sitting in Europe, in London, that gentleman from Holland is sitting here. I said, now make him to wait. You straight away say, well, I have filed a European application, let it be protected first, and then I will give you the license. Give you any kind of thing. But you block your, because the day he started, but thank God, my client is so loyal to me, I gave him these suggestions beforehand. He remembered that. When he had a negotiation in the Hotel of London with that gentleman, immediately he called me. He said, sir, I met this gentleman from Holland. I said, please, tomorrow morning we'll be filing the application in the European country by doing that kind of, even we are very, very apprehensive whether he has already taken that trademark or not. In his country, especially in Holland. We found an immediately lawyer from European country and asked her to file the trademark application instantly. So in that country, the system is much faster. In the midnight, even she filed the application. So that is the way you have to think for your global business and all those things. So industrial, protecting the industrial design is also very, very crucial. You have to remember that also. So once you file this international design application, it offers a low cost definitely, but it offices in 44, only the 42 member countries. So such and protection is also necessary. copyright, yesterday I mentioned very clearly, this is a one convention. You remember it is a very, beneficial for you. Once you register the copyright in India, you cross the boundary of India with this kind of the protection. It is very broad spectrum. We have, because especially for one particular organization, by the copyright protection we stopped their business, especially the country like Romania. So because Romanian court asked us that please give us the translated copy. That translation is very crucial, you have to be careful, you take the support of the IP attorneys. That should be legally translated copy. Then court read it, immediately passed the injunction. No, it is a strategic use. You just remember, it is not just like your you're taking your trade license. Many people come and they say, okay, I want to take the trademark. It's not that. Don't do that, because IP is very crucial and nowadays day by day it is becoming more complicated. Now artificial intelligence, yesterday you had a session. Now every corner of the country, not only our country is much behind in that way, I can say, because we have not started any kind of law to operate this kind of to regulate even AI. But in England, I have already seen that book, the law of artificial intelligence. So therefore, we are still, walking behind with a global standard. So strategy you have to make. Sit with your lawyer, good IP lawyer, and talk to him very openly and take all kind of advice, whatever you need from that person. So commercialization is very important. First is your creation. You just see this the core circle. Then next level you think for the protection. That is your IP attorney. The creation is also, if you want to choose a trademark, then definitely this creation level comes. Then you take the IP attorneys. I said, in a foreign country, they always call the IP attorneys, they start their business. But in India, what happens, we start the business, then you go to the lawyer. It is too late. And then we, bang our head against the wall of the court and every problem you face. So protection, then expansion, and then commercialization. You just remember these are the stages. You have to move in your business with this help of the IP. So benefits, definitely everybody knows. We have made a lot of sessions for the benefits and all those things. I am not killing much of your time before the lunch, and otherwise you'll be cursing me inwardly. Rewards, enterprising is there. Now, IP commercialization, this is the process you follow. IP protection, commercialization, IP sale. That is very important part of it. I don't know, whether you all are able to see it. I'm just moving that side. The red signal is not working here. Some problem is there. Anyway, the IP sale is very important. Like it's a kind of the property, how you use it, and it is a one-time sale. That is a kind of the assignment, or the licensing. It is the regulated by a time frame. That is a kind of the agreement you make with this IP creator, or you just create your franchisee or agent or stockist, whatever. The same licensing is very important. So prospect of development, it is your expertise, the network, the technology scanning and technology assessment, IT policies. That is also very important for you. You have to have your own IP policies, how you control it. That is your in-house thing. Then technology matching is also here. And for startups, it is extremely important. Commercialization, how you do that? A demand. So commercialization, first of all, once you create that property, you always look for whether you want to do the business by yourself. Like KFC, they have created the IP, or the McDonald's. Just imagine, when I was young, I always heard about that because I had a lot of international friends. And they used to call me, they used to tell me I'm in a Walmart. I said, what is a Walmart? Even though sometimes they send me the gifts from the Walmart before the Christmas. So that is a very big chain of, this like the retailing centers, like our the Reliance Retail, Reliance Digital, etc., in our India, following that concept only. So that particular company, the KFC, he never came. No American is in India, but a brand has traveled from that country to that country only by IP. With the journey of IP, he has expanded his business. No question of doing this kind of machineries or the land or buying. Nothing is required. But I will create a good IP, good value with a goodwill. Then I'll go for the next country, or I'll create the next level of business, like by franchise. I have one client in Calcutta, the restaurant. It's a very small chain. Actually, this is a personal name. I'm just giving you the practical example. That is much better than even talking about the theories. So he came with a name. It's a personal name. Personal name cannot be protected as a trademark. That is why Haldiram is not yet protected in our country properly. Because n number of cases are pending in Supreme Court, and their brothers are fighting among themselves. The same with the Gupta brothers in Calcutta. Same with the Bikaram. Now, what is the situation I'm giving you? His name is a Gautam. So I used to go to that center because that was the time I used to practicing my driving very freely on a highway in the late night, and I used to have coffee from his shop. The very good coffee maker in Calcutta. So I approached him that you should go for the trademark, and he said, okay, I'll talk to my accountant. I said, okay. I just gave him a pass. So next time I didn't bother about him. I went to the shop, I started drinking the coffee without talking about all those things. Now, one day, he was telling me, that somebody came to my shop and he was telling me to protect the trademark. Sir, I want to talk to you. I said, okay. But I didn't give him anything about my identity, like my mobile number, nothing. I was standing on the shop, even I was still keeping him on the examination. So I said, okay, what do you want? Why you want a trademark right now? So he said, sir, somebody approached me and he gave me the entire story, the background story. I said, your trademark cannot be registered. I did a research on that later on. He said, sir, why sir? His face was totally pale. I said, it is a personal name. And not only that, Gautam is already there in existence, but they are not registered. I did a Google search, I found it. Now you tell me when you started your business. He gave me the idea, enter thing. He is doing the business for 6 to 7 years. I said, okay, little safe journey is there for him. Now I told him the way you are writing the Gautam, the simple font, it cannot be protected. So he created that G before that in a very unique way. I helped him how to do that and the designing part and all those things. And then it followed for the registration, but it granted the registration. One fine morning, he visited my office. He told me, sir, I'm just rushing to the court, I cannot talk to you because you talk to my team. He says, now I personally want to talk to you, sir, only for 5 minutes. I beg of you. I said, yes, please tell me very quickly. I was walking through the corridor of my office, then I was talking to him. He said, sir, honestly confessing to you, you helped me to earn crores without doing any business. And how? Because now many companies, many coffee sellers in different areas of West Bengal are approaching me, give the license. or franchisee that I want to sell the coffee with your brand name, because your brand name is selling like anything. And I said you have to be very careful, because once you give the license, you have to think for the quality control. You have to monitor it. Do you have such kind of team? He said no, I must stop it. Until today, he has not given a single franchisee. He is doing by himself. He is not that much greedy for the business. He says, sir, I know what is the value of the IP today. Even one day, one IPS lady, she went to that shop and he was telling her, educating her that how to do the IP and all those things with the trademark registration. Anyway, this is interesting. Like commercialization of the IP assets, but turning into the business also is very, very important, that I have mentioned also. I don't know if there's some technical glitch is there, but other points are not coming. Oh, that is in this way. The transforming an idea into the invention, that is also very good, into an object. The commercial sale and monetization is very, very important. Don't hold your IP idle. That I suggest you. Licensing intellectual property, that I have already mentioned. And royalties. You try to collect the revenues and royalties through the assignment. Licensing agreement. The IP license is a kind of the legal agreement that you should take help of the IP lawyer, because otherwise it will be very, very complicated for you to understand all those things. But you have to remember that agreement is necessary. Like whenever you do anything, like you go to rent a place, you have to sign a rent agreement. So similarly, the licensing agreement is there. You have to consult with a lawyer, good lawyer, those who understands the various points of the IP. Like DRDO said that we have this standard draft and all those things. That is definitely made by the in-house IP, because I noticed that DRDO has a lot of IP team. Even my law firm, when I started my journey of the IP, the DRDO is their main client, like RDSO. So the patent commercialization is little complicated, the technology transfers and all those things. So you have to just have a look of that very quickly. And if you want to do that later on, then definitely we are there to guide you and give you the advice. Of course, I will not charge initially for that, as you are an MSME company. And we always do that. Also, if the company is coming, small company and all those things, we do the free advice initially, like what should you do, what should not you do, and how to protect yourself. Even sometimes we say this, hold your IP for some time, let it grow, then you file the registration. Don't jump for immediate protection, because some of the areas of the IP request your commercial credentials, we call it. So that you have to think. That's why you have to talk to the good IP attorney. Assignment is there, patent licensing is there for royalties. You see the various types of patent licensing is there. Patent licensing is very crucial. One particular area is called compulsory licensing. So there was a very famous case, Natco versus Bayer. So Bayer is a German company. They had one particular product. I don't know exactly, can't remember the brand name. It happened in 2012. So what is a compulsory licensing? Like suppose you file a patent application. Your patent is protected, but still for the benefit of the mankind, especially for the healthcare, the government can give license to the third party, another company, to manufacture the same product, provided they are making it for the benefit of the public. So in that particular case is a Natco, this is an Indian company. They proved that I can produce this medicine in a lower price. Then Government of India has given the compulsory licensing to the third company. Of course, the buyer trying to drag this particular challenge, this compulsory licensing in the Supreme Court also. It's a very important case in our country. So These are the different types of the patent licensing. That's the compulsory licensing I was talking about. Cross licensing is there. It is little complicated. I'm not just utilizing this time, precious time for you. For this, you can have a look of that. It is called cross licensing. That is also a very, very important area of this. It's like means a similar license you can create for this simultaneous company for this same kind of a technology. That is a very conditional also. So you see these are many things are there because you want to earn more, you want to cut the cost, or many aspects are there for the cross licensing. Patent pool is there to a third party, all those things. I'm not going much into that. The process of patent monetization. You see this non-viable and all those things, and then disclosures, IP administration. Filing for the patent. This part is your creating your patent protection ground, then filing the patent, then straight away you go for that level, I think. Similarly, the trademark is also there. Like I have already explained you how to protect your trademark globally, as well as you go for the commercialization. Like you can create the licensing body in a foreign country also. So these are the benefits of trademark licensing. I said, you can do. I have given you a practical example. So copyright also the same way you can do that. It's almost similar. Nothing is like a very complicated in nature. Do the same way. That is also there in the copyright licensing section 30 is there also. This is very important, the asset increase, because the monetization of IP assets, what it does really. The assets, then liability also increase, but it is a less risk also. Equity is there, also increases greatly. Definitely your equity value of the company increases, then you go for public limited company, you can go for the share market. Also profit increases definitely greatly. Decreases means likelihood, means like it is helping you to stop the likelihood from the competitive market. Cash flow definitely increases. So if you have any question, definitely in respect of the IP, the intellectual property or its complexity or any kind of the situation, then definitely our law firm will be always there, and will be, although we are based in Calcutta, but very soon we have the global offices also many countries, as our this experience has been appreciated by many country lawyers and all those things. And we'll be very happy to start our operation, physical operations and etc. in Hyderabad also. So you can definitely step into our office and can discuss with our team also here. And we will be always here with you for your business protection. Thank you very much for your time.
Thank you, sir. Thank you for giving the valuable inputs. Now we'll break for lunch and rejoin at 2:45, 2:30, sir.